scare you, and I'm here to make it a little less scary, or even make you feel like we might have an idea of what's going on with all of this. So I've got two guides. This one, please don't worry if you can't read it, we can circulate this afterwards because when in doubt, handout. But so this is just setting out, as Edward mentioned, you can have 1993 Hague Convention, or overseas, or common law, or domestic. So there's a few kind of chains you can go down, and our nice little catch-all provision at the bottom, when in doubt, immigration advice. So this is just setting out some of the procedure that you will need to comply with if you want to go via if you have a client who wants to go via any of these routes, or as Edward said, you find yourself catapulted into the middle of one of these routes and you need to work out, was the previous bit done right and what do we do next? So we'll consider a couple of scenarios that you might come across, some potential pitfalls and kind of how you might be able to get yourself out of them. The first one is your Madonna or Angelina Jolie comes along and says, haven't got enough kids, could do with another one. The client they've actually moved to the UK, it's the place to be, and they'd like to adopt a child from another country, and your key question is, can they? First thing to notice is that some countries are restricted and you cannot adopt children from there, much as you may like to. There is I've put a link down below there for the sort of updating gov.uk website, but the current list as it stands is Cambodia, Guatemala, Nepal, Haiti, Ethiopia, and actually recently Nigeria. So if your client mentions any one of those countries to you, red flags should be pinging and you'll be advising them this is a no-can-do. The reasons, the Gov website helpfully sets out the reasons exactly why you can't, and it's generally risk of trafficking, falsification of documents, coercion of birth mothers, inadequate legal framework, some fairly sort of big red flag reasons. So that's a no-can-do. The second classic pitfall is there's sort of a humanitarian problem, I suppose. So they might be tempted to visit another country with a view to adopting a child there and bringing them back to the UK here. However, you've got to be really, really careful because it is a criminal offence under Section 83 of the Adoption Children Act 2002 for individuals habitually resident in the British Isles to bring a child into England for the purposes of adoption here if the correct procedure has not been followed. So again, you want to make sure that you're sticking on the very right side of the law, otherwise your client might think they've had a nice adoption and come back and find themselves arrested. So the first way you might want to avoid that is consider a convention adoption. So if the country that the client wishes to adopt from is a signatory, then it is probably your best bet here with England as the receiving state. So in the previous couple of slides, we set out the kind of procedure that the actual Hague Convention sets out. However, England and Wales, of course, has some other specific rules that you might want to consider following. And these are found at Part 3, Chapter 1 of the AFA Regulations 2005. So you're going to want to consider those pretty carefully before advising your client on their sort of best next steps to ensure that everything is fully compliant. The third pitfall, possibly more likely to happen, for example, in America, but there is an adoption abroad, but the child's legal relationship with the birth family was not completely severed. So, i.e., this is what's called a simple adoption. So in the UK, if you adopt a child, it can only be a full adoption, i.e. the relationship between the birth family and your family is completely severed, but in America, for example, there can be a lot of contact still taking place. It's not the case here, but it's just something to be aware of there. Again, there is a solution here. If this is something your client deems as a problem, there is a mechanism under Section 88 of the Adoption Children Act 2002 for such scenarios if the circumstances are appropriate. So this is a moment for sort of discussion with your client and seeing A, if these circumstances apply, and B, if they deem this particular thing to actually be an issue for them. They might not. The second big problem is immigration confusion. So, the client has adopted a child from another country and would like to bring the child here. The key question is, can they? So, if it's a convention adoption, where the adoption order is made in the state of origin rather than in England and Wales, provided that the adoptive parents have British nationality and are habitually resident here, the child will automatically have British citizenship and won't be subject to immigration controls. So this is probably your best bet, if at all possible, to steer your client in that direction. But if England and Wales is the receiving state, then entry clearance is required, and we've got a list of sort of actions there that you'll need to go through to make sure that you are, again, fully compliant. And as we set out in the procedure slide, there's Article 17 checks that go on under the 1993 Hague Convention, so you'll want to be bearing these considerations in mind when those checks are going ahead to make sure that, in effect, everything for the child's entry to the UK is all sorted before the final adoption order is made. If you've got an overseas adoption, this is a little simpler in a way, because depending on whether the adoptive parents are British citizens or not, the child may or may not have a right of entry. And even if they do, that doesn't necessarily confer British citizenship upon the child, which again is a little tricky. So again, our best advice here is that if you're approached by potential clients who have an overseas adoption order and would wish to bring their child here, consider a joint approach with an immigration lawyer and figure out how you can best bring them here in a way that's going to be fully compliant. If you're seeking common law recognition of an adoption order, so that's basically one that's going to be neither the Hague 1993 nor overseas, these are very rare, but they do come up occasionally. Again, it would appear, it's not entirely clear, but it would appear that the child will not be regarded as legally adopted under the Immigration Act. And this is section 33(1), and this was considered in the case of Crown against Secretary of State for Home Office, ex parte Tahid. So again, this is slightly problematic. So again, we would strongly advise at the outset doing a joint approach with an immigration lawyer and work out again how best to make this compliant to avoid ending up in any Section 83 pitfalls, ballet shoes style. So hopefully that helps you out with just a few of the problems that you might come up against and how to make it a little less scary. But if you've got any questions, if you have anything else you'd like to add, I think that concludes us.